Good morning, everyone, and thank you for joining our event with our guest speaker, Professor Deepa Badrinarayana from Chapman University. I'm Aubin Nzaou, and I'm delighted to say a few words about our program, which is funded by the European Commission through the H2020 and Marie Curie Actions. So next month, our series will also feature 3 different speakers, including Professor Katrina Wiman from New York University, Professor Kerry Coglianesi from the University of Pennsylvania, and Professor Don Elliott from Yale University. So please feel free to visit our website, www.law.uh.edu/EENR where you will find the upcoming events in the series and the great lineup of our past sessions and speakers. Feel free to use the chat box for your questions, and in due course, I will be providing you with the name and the email address of the person in charge of the CLE credit when it comes to our event. I now will turn it over to Professor Victor Flatt, our chair and the co-director of the EENR Center.
Thank you so much, Aubin. Welcome, everyone. We're really happy to have you here, and we're very happy to have Professor Deepa Badrinarayana here to speak to us today on, of course, the pursuit of environmental justice. And Professor Badrinarayana, the so-called godfather of environmental law, when he saw the title said, "Oh boy, you guys are really going to go for it today, aren't you?" And so yes, the answer to that is yes. Professor Badrinarayana is a professor of law at Fowler School at Chapman University. She teaches in international law, international environmental law, climate change, and torts. Her scholarship is primarily focused on climate change and environmental law, with emphasis on human rights and international law dimensions. And those of you who are in the environmental law community who follow our discussions will know that she is a very important voice on many discussions about climate and energy and human rights. And I'm pleased to say, I feel like I knew her back when she was just getting started, and have really enjoyed watching her career grow and all of the contributions she has made. Again, as Aubin noted, you can put your questions in the chat. Again, we are trying to do this a bit more informally so that I may even ask if you want to raise your question and have the discussion. This is being recorded, and you will see CLE credits before the end of the session. So without further ado, I would like to turn it over to Deepa.
Thank you so much. So good morning, everyone. First of all, I would like to begin by thanking EENR Center and Aubin for having contacted me and invited me to speak today. This is such a terrific series, and I've been watching over the year plus that you've been putting together some really interesting talks out there, and I have always been, it's too early for me to get up and watch, but I've been watching the recordings and it's been great. And I'd also like to thank Professor Flatt today, and he's right, he was very much involved very early in my career, and I attribute my continuing to be in academics directly to him. I believe he was on my tenure committee. I'm not sure, I still don't know, I've never been told this. So I don't know. So it's really a special honor and privilege to be here today, to be speaking in one of his programs. So in terms of this paper itself, I see some familiar faces who might have, already heard this paper before. So feel free to pitch in and say, hey, I got this. You didn't incorporate some of these changes. But let me also say something else, that this project began probably 4 years back. So there was this moment when I was thinking about environmental justice for the longest time, had taught the courses, and somehow something was just not clicking. And then suddenly I read this article on entrenchment, And I said to myself, what's this concept of entrenchment? And it occurred to me that, the 14th Amendment is an entrenched provision, which means that you just cannot change it, right? And then it occurred to me, but what about the judiciary saying you need intent, right, to pursue a claim under the Equal Protection Clause? Isn't that essentially changing it? So without realizing what a deep, water I'm going to wade into, I said, let's go right there. And so the result has been 4.5 years in which I've been soliciting different opinions. And I still remember Professor Flatt, I threw this on the environmental law listserv and said, environmental justice, I don't recall the exact question, but something to the effect that isn't it all about discriminatory environmental laws? And I still recall his response where he said, no, that's the reason why the Clean Air Act, is based on health for everyone, right? That the purpose of environmental law is to provide good environmental conditions for everyone. And that kind of put another kind of obstacle in my thinking. I said, true. So where does the discriminatory part come? Now, I'm getting ahead with the story, but I'm mentioning that just to kind of say, why it took me so long, and just kind of to give you this perspective that I've come here after 4 years of studying constitutional law, which is not my field, driven by so many questions and pushbacks that I received. And I'm not quite sure I get it all, very well right now either. So please feel free to raise questions and comments and give me suggestions. Now that's kind of like the big background, but let me start now with the real presentation. And I'd like to begin by saying first that my own background in environmental law is in India, right? It began in India. So very quickly, when I grew up in India, years back, we did not have, as a child, for instance, did not have the kind of environmental problems that are quite evident now in India, and that are quite evident right now here too, right? So it seemed to be something that was more like the lake is polluted from sewage, or there was no access to drinking water. So it seemed more like developmental related problems as opposed to pollution related problems. And there was some degradation that was occurring for sure. So years after, when I went to law school, and then I met Nick Robinson from PACE when I was at law school in India, and he kind of pulled me into this field, I was still left with this question: what is environmental law? What does it really do? How do we kind of bring it to India? What will it do in India? Especially since there's so much pushback in India for environmental protection, because people still need to get food on their table. So what we need to do is really develop. So for me, the question was, what does environmental law do? How do you frame environmental laws in a country where there's a lot of poverty and great income gaps? So when I came to the United States, I came quite pretty much set with this idea that environmental law becomes relevant only after you develop. And then it struck me, it's not after, it's because, right? It's because of the kind of industrial and development policies that have been pursued that environmental law has become relevant, right? That you actually sacrifice a lot, and then it becomes inevitable that some kind of regulatory action has to be taken. And then I took this one class on environmental justice in PACE, where I was introduced to this additional dimension of environmental justice. So it was hard enough to kind of wrap my mind around the question of environmental law and how it can work in the context of development and in low, countries where there are income gaps. And then boom, here's another dimension that in one of the foremost economies, right? The biggest economies in the world, there are gaps within the environmental, law discourse. And so, but I left that behind for the longest time. But I was so caught up, I was so taken by this, that I taught a course or two back at Chapman as well, and it still didn't click together. I just couldn't wrap my mind around this question of environmental justice, what the legal implications of environmental justice were, and how it would actually work. And I'll add a quick dimension as well to this, which is I come from a country where there are caste-based discrimination practices that take place. So whereas there are race-based discrimination, and in India there are race-based discrimination as well, but it's not as predominant as it is in, say, it has been in the United States and other countries in the world. But discrimination is not something that was in itself new to me. And I'd like to admit that having been somebody from the higher caste, I also understood as we studied law in India, how these things get internalized in a very subtle manner that you don't even realize, that there are ways of being that are just not constitutionally correct or even correct per se over a period of time. But at the same time, I think it also gave me a rich perspective that sometimes these process of internalization mean that sometimes it's a subconscious or unconscious ways of being that could have large impacts without even one realizing or wanting to consciously discriminate or impact others in that way. But at the same time, I'll say that my own experience of how discrimination works in the United States is quite limited to the number of years I've spent here. So I always, start off this presentation by apologizing, and I'll do the same here, for any thing that I might say that is not well informed or well grounded in the history here. So with that, let me begin for the third time and get into the actual questions. So the paper itself, I kind of start by asking everyone to think about, America's founding moment, right? So if you think about July 4th, 1776, I'm thinking must have been a very beautiful day, right? Must have been a very beautiful spring day or summer day. It was likely sunny. There must have been clear skies. And here was a country that wanted to have a new principled beginning, right? So it was founded on a new principle. The founders had battled long and hard against a sovereign regime that they found unjust and illegitimate, right? Forcing its American colony to bear a disproportionate share of economic burden with no recourse to parliamentary representation or judicial remedy, reflecting the core character of the British system of government, right? And so the idea was, we are going to form a nation that is in principle different from our colony, from our colonial government. So the founders took considerable time, right, and spent considerable amount of effort and drafted the Declaration of Independence. And the Declaration of Independence articulated the political philosophy of the United States, who we are as a country, who we want to be as a country. Like I said, I had a little computer glitch, so I don't have the PowerPoint, so I'll read slowly for us today, the Declaration of Independence. And what does it say? Partially, all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, right? This is the part about, all men are being created equal that always gets to me personally, right? But this is our Declaration of Independence: life, liberty, and the pursuit of happiness. Now, the declaration was deeply deliberated. It drew ideas from a large pool of Western philosophical thought and distilled them into a representative form of government, charged with a duty to secure at least 3 explicit, unalienable or inalienable rights: life, liberty, and the pursuit of happiness. However, it took about another decade or so for the founders to implement the principles set out in the form of the United States Constitution, which was ratified on June 21st, 1788. So the Constitution divided the governmental authority among three branches, as we very well know, the Congress, the executive, and the judiciary. And what we have at this time between the Declaration of Independence and later the Constitution is a polity in which there were about 2.2 million people, whites and Native Americans, and about 576,000 Black people. And we know at that point, the Blacks in the country were considered much like women and children, chattels, and the Blacks were slaves, right? And the Declaration, although it said all men were equal, did not include these constituencies, the Blacks, the children, and women. But what we need to keep in mind, given the time and the period, is that the principle had an enduring effect. So over a period of time, what we have seen from the moment of the Declaration of Independence through the Constitution is the eventual abolition of slavery, including by some of the founders, George Washington, Benjamin Franklin, all of whom could not quite reconcile the principle with the reality, right? So the country that we became was one that tried to pursue the very principle on which we were founded, leading up to the 14th Amendment and to the adoption of the Equal Protection Clause. So the question is, how far has this egalitarianism gone? And this is a very crucial moment in which we're asking this question. And a few years back, our answer would have been, well, we've gone pretty far. The judiciary has actually looked into this clause and given voice to rights to make it very meaningful to the realities of society that we have. But we also know that the task of the judiciary is onerous, because we have a very broad principle which has to be bridged, right? The judiciary has the task of bridging the principle with practice and with a few tools to guide its decisions. So the question is, what has actually become of the 14th Amendment, specifically the Equal Protection Clause, and what has its impact been on environmental justice and the application of environmental laws to different constituencies? And here I'll begin the story by talking about the Equal Protection Clause itself. So the interpretation of the Equal Protection Clause, and again, I'm not a constitutional law expert, so I'm sure there are others who might be much more of experts in this field, but I want to give an introduction that is relevant to the discussion on environmental justice. So from that perspective, we can broadly or generally divide the Equal Protection Clause jurisprudence into two periods: pre-Washington v. Davis and post-Washington v. Davis. In the pre-Washington v. Davis period, notably in the Hicks case, the Supreme Court found that, very generally speaking, the disparate impact was subject to scrutiny, right, or would trigger scrutiny of the court under the Equal Protection Clause. Disparate impact would be an adequate consequence of state action that could trigger judicial review under the Equal Protection Clause. And then we move forward to Washington v. Davis. With Washington v. Davis, the central interpretation of the Equal Protection Clause changed. It was a case that was not brought under the 14th Amendment. It was a Fifth Amendment case, right? And the court, nevertheless, noted as follows. So Justice White, who wrote the majority opinion, specifically noted that the central purpose of the Equal Protection Clause was to prevent official conduct discriminating on the basis of race, and that racially disproportionate impact alone would not make a conduct unconstitutional. Right? So racially disproportionate impact alone would not make a conduct unconstitutional. The court was very careful in distinguishing the facts and its application and its interpretation in Davis from earlier cases, including a case under Title VII, which the court said was very different from its interpretation of the constitutional protection. Right? So it was careful in making that distinction. Now, following the decision in Washington v. Davis, in a couple of years, there was another case decided by the Supreme Court, Personnel Administrators of Massachusetts versus Feeney. Now, in this particular case, the court tightened its interpretation of the Equal Protection Clause, holding that not only was disparate impact alone adequate to trigger judicial review, but further holding that discriminatory intent meant that an action was taken because of, and not merely in spite of its discriminatory effect. So a plaintiff or a petitioner moving the court had to show that the state action was motivated by a racial animus, that because of the discriminatory effect, the state action was taken and not in spite of. So a really specific kind of intent, right? A very specific kind of intent was introduced to the test. Now the question is, what has been the effect of all of this on environmental application of environmental laws, and what has been the impact insofar as the environmental justice discourse is concerned? And for that, very quickly, and this is again well documented and well-researched scholarship is out there on this question. So I'll go on to say very briefly that the journey in regard to environmental justice has been as follows. Now, the first part is we do have, as Professor Flatt reminded me in his email, environmental laws that don't really directly talk about discriminatory application in any manner, right? What do the environmental laws do? Starting with the National Environmental Protection Act. They set out a framework for environmental or evaluation of environmental impacts, and all the cases that followed in the regulations and laws that followed in the 70s onwards focus on ensuring that environmental laws are applied in a manner that is in no way discriminatory, right? It tries to achieve the maximum best qualities of air and water within a regulatory framework that is achievable. So where does the question of environmental justice pop in? So what we have realized over the years, as many of you in this forum know, is that some communities realized, notably communities of color and low-income communities, realized that they were not benefiting from environmental protection laws in the same ways that others were. So the question was, so why is that happening? What should we do about this? And what has been the impact of the Supreme Court's interpretation of the Equal Protection Clause on all of this? So what we see is that, if you give me a minute, what we see here is that over the period of time that the Davis application of intent has kind of flowed into the application in regard to environmental protection challenges. So notably, in the case Rice versus Kay, where an Equal Protection Clause challenge was brought in regard to a landfill that was located in a predominantly Black community, the court actually noted and that the problem was that there was no proof of discriminatory intent in the permitting process. They said the petitioners could not show that the landfill had been located or the permit had been granted with the intent to discriminate against the community in that particular situation. Disparate impact alone would not be adequate to move that challenge forward. So there had to be proof of intent. So what the environmental justice plaintiffs did next was to turn to the Civil Rights Act, Title VI. So Title VI of the Civil Rights Act is a landmark. I mean, the Civil Rights Act itself is a landmark legislation that was passed by Congress with the purpose of ending segregation and providing full citizenship to all Americans, including notably Black Americans, specifically to ensure that voting rights, desegregation, etc., were provided to communities that had long been disenfranchised. Now, in regard to the environmental protection or environmental justice aspect of this, we specifically have Section 601 and 602, which are quite limited in scope in themselves, because what they do is they prescribe discrimination in federally assisted programs. So according to Section 601, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So this was interpreted over a period of time to allow lawsuits where, based on discriminatory impact. So the environmental justice plaintiffs also pursued this particular provision and to get remedies against discriminatory impact in the environmental context, environmental permitting context. So that was put stop, or that came to an end when you look at Aubin versus Southwestern Waste Management Corporation, a case in which they found that a lot of the activities or permitting that was given to solid waste disposal was located in a community with high minority population. So the question was whether that would actually trigger action through Title VI, Section 601. What the court did was to kind of use the interpretation in the equal protection with regard to equal protection clause and hold that it wouldn't. It wouldn't because there was no proof of discriminatory intent. And disparate impact alone was not adequate to trigger this particular, to trigger or to warrant an injunction in this particular case, even though it was clear that minority population were disproportionately impacted. So the next question was, and the next question was there any other legal remedy left for environmental justice plaintiffs to pursue? So environmental justice plaintiffs then moved to Section 602. But however, notably in South Camden Citizens in Action versus New Jersey Department of Environmental Protection, the court found that Section 602 could not be used as a proxy for Section 601. So what was Section 602 about? Section 602 actually allowed federal agencies to pass regulations implementing Section 601. So the EPA actually passed regulations that would prevent environmental or that would allow any kind of review based on disparate impact. But the court said, well, we cannot allow you to pursue a remedy under Section 602, which is essentially giving effect to Section 601 when we won't allow a remedy under Section 601. So in other words, the remedy that you pursue under Section 602 cannot be greater and different than the remedy that is allowed under Section 601. So if an environmental justice plaintiff cannot bring an action based on discriminatory impact or disparate impact under Section 601, we cannot allow the same under Section 602. So the result was that eventually Title VI was no longer an option available for environmental justice plaintiffs either. So the question is, where do we go from here? Now, what has happened is, of course, that the executive has stepped in, right? So the EPA has stepped in, and it has, and as well as, there have been executive orders that have been passed under, starting with President Clinton, and the executive order that's in place consistently reads as follows. I'm reading the 1998 standard definition of environmental justice, which says that the fair treatment of people of all races, cultures, incomes, and educational levels with respect to the development and enforcement of environmental laws, regulations, and policies. Fair treatment implies that no population should be forced to shoulder a disproportionate share of exposure to the negative effects of pollution due to lack of political or economic strength. Right. So it's very clear from this particular definition that equal protection, non-discrimination really comes down to making sure that there's a fair burden sharing of the pollution and the cost of development, right? So it's a standard that would clearly require consideration of disparate impact and not just any intentional discrimination alone. But the problem is, of course, that even though this is a very welcome, important step, right? Even though this is a very important, welcome step, one that should neither be abandoned nor ignored, because the executive is the one at the end of the day through the permitting process and review of different permits that has the ability to, effectuate and ensure that there's no discriminatory distribution of burden, right? It is very critical for the executive branch to be involved. So whatever I'm going to say going forward is it should not in any way be construed as undermining executive level action to make sure that there is a fair treatment and fair distribution of environmental burden. But the point here is that I think is important for us to consider is what happens when the executive fails in this particular mission. The remedy is very limited. It's not that there are no remedies. There is, after all, an Office of Civil Rights that provides administrative review process. And there's also the External Civil Rights Compliance Office within the Office of the General Counsel. And particularly within the Biden administration, there are ongoing efforts to strengthen administrative review and to deliver environmental justice. But what we've seen is, if you look at a couple of administrative cases, even though there is room for challenging administrative decisions on the ground that they do not adequately enforce the mandate set out for them, often the time taken to actually completely review these challenges have not really been very robust. And environmental justice plaintiffs have had very limited success as well because of that reason in pursuing any remedies for failures within the executive framework or executive mandate. So while much has been done on the executive front, it is not failure proof, so to speak, right? There are a lot of administrative hurdles to making sure that that the mandate is given or the regulation is given full effect. So, for instance, I came across this case, Californians for Renewable Energy versus United States Environmental Protection Agency, where the court upheld the declaratory relief against EPA, chastising it for arguing that it had no mandatory duty to act on Title VI complaints. So that's kind of a positive development to kind of show that there's been a great judicial focus to make sure that there is enforcement. But at the same time, it takes a lot of time and effort to pursue these remedies, and it's not always effective. So what else are we left with? So the other option, of course, that's worth considering for a minute is what Congress has been doing. I would say not much, but there have been efforts within Congress to pass legislation on environmental justice. So we do have the Booker Environmental Justice Bill, which tried to codify, right, which would essentially codify the 1994 executive order and would state, and has stated as its objectives, requiring federal agencies to address disparate environment and health impacts on populations of color, communities of color, indigenous communities, and low-income communities, and to strengthen the rule of law in regard to environmental justice, as well as increase administrative coordination and cooperation among different agencies, to provide subjects of the legislation meaningful access to public information and opportunities for participation in decision-making affecting human health and the environment, and to mitigate inequitable distribution of burdens and benefits, as well as require consideration of cumulative impacts in permitting decisions, and clarify congressional intent to afford rights of action pursuant to certain statutes and common law claims, and to allow a private right of action under Title VI of the Civil Rights Act. And the problem is here, of course, that beyond our reading, we haven't seen much progress, and we're unlikely to see much progress, right, on the congressional front. But what is critical here is to note what is really missing in the current debate within the executive order, right, or within the executive purview, the right to pursue a remedy, a private cause of action. And I think this is very fundamental to our legal system, to our tradition as a common law legal system, which Congress tries to address, but which has not seen any progress, right? So the result is on the one, and plus, and this is of course probably, presumably, challengeable. But if you look at the Supreme Court's jurisprudence generally on disparate impact with respect to, say, fair housing, the court has been tightening the scope of disparate impact review as well. So for instance, assume that the congressional legislation goes forward. But if you look at Texas Department of Housing case, the Supreme Court held that to be constitutionally permissible, disparate impact law could only remove artificial, arbitrary, and unnecessary barriers and not displace valid governmental policies or interfere with the ability of those regulated to sustain a vibrant and dynamic free enterprise system. So this raises the question that even where an environmental justice law to pass at the congressional level, especially in the environmental context, can it be limited by this standard? Because particularly with respect to environmental permitting, we do get into the question of strong governmental policies that has to balance economic interests on the one hand versus other interests. So I am skeptical that even with the congressional legislation, in light of the Supreme Court's interpretation of disparate impact, we'll see a great deal of review and meaningful progress. Again, this is not to diss any effort. I think we need efforts on all fronts. So where does that really leave us? Where have we come to at this point? So at this point, having given this background, I'll switch to some of the other possibilities. In terms of reformulating environmental justice and what has happened to the environmental movement, given this kind of wall that we have hit, right? So with the environmental justice movement, now the wall we have hit is whatever can be achieved through the administrative process. And it seems to be impossible to pursue judicial remedies, even though that is something that is so fundamental to our legal system. So especially in light of climate change, what we see is an emergence of a lot of rights-based jurisprudence and efforts to expand the scope of rights. And so where all has this happened? So I'll start with one of the latest amendments with New York State. One place where it's occurring is at the state level. This is a good development. It's an excellent development because I think we as I started as a society, right, as a country, believe in the Constitution, right? We have a Constitution and we believe that it is going to provide us the normative framework and foundation on which we are going to move forward with our decisions. And the Bill of Rights generally is a critical component of this process. So to actually codify and formally adopt within the Constitution a right to clean and safe environment is a very meaningful normative exercise. And I think we have states that have actually already done this and have had some success in implementing this particular right within the state constitutional scheme. Now, what's the challenge to this? The challenge to this are twofold. The first, of course, is will all states do it, right? Which are the states that will do it? Which are the states that won't do it? And was not the very purpose of having a federal constitution and a federal Bill of Rights to ensure that state action will not alone determine which Americans get rights, which Americans don't get certain rights, right? That all Americans should be entitled to a pool of rights. And among them would be equal protection. And presumably, as we see environmental, and I'll come to this again, environmental issues becoming one with so many of the other rights, right? Your right to life, as has been interpreted in other countries, depends on a healthy environment. This notion, of course, is not just a foreign notion. It began here in the United States. The right to life, as including more than just being alive, is very much an American jurisprudence. So to leave this to states alone, I think, is not quite in the spirit of where we began. And two, even within that scheme, what would it mean for states to adopt such an amendment? It would mean that at the end of the day, if there is a dispute, it would go back to the judiciary to determine the scope of this right. And what would the judiciary do? How would it decide? Do we have some kind of markers to help us think through that question? So I think that's still an open question, but it's an important development. What else has happened? The second thing that has happened is, especially in the context of climate change, we see that there's a robust reemergence of the group that feels disenfranchised in this process as well. So, for instance, the very notable Juliana case, right, shows two things. The first thing that it shows is that, wait, we are not just talking about, communities of color. We are not just talking about low-income communities, etc. We're also talking about youth. We're talking about people, young children, as a specific class that is also being discriminated against, that we don't feel we have equal protection of the laws that was promised. That's one development. The second development with respect to the Juliana case is that given the limits of pursuing a remedy within the 14th Amendment Equal Protection Clause, they move to the Due Process Clause. Right, there's a great shift to the due process clause. Others in academia have written extensively and persuasively about the importance of interpreting the due process clause to effectuate and recognize a right to environmental protection or clean and safe environment as part of the right to life, liberty, property, etc. Right, but again, the question is, as we've seen with the due process clause jurisprudence, where does that norm come from? What should we base our decisions within the due process clause on? And there have been different judicial opinions about this. With Justice Harlan in an earlier case noting that it's probably going to come from, what we value as a society, right? Because the due process clause, what is this? What is the, principle of judicial interpretation? What does the judiciary rely on? What should it rely on? So, the key is, even to interpret the due process clause, you really have to look at our normative value and say, from where will we draw that interpretation to include equal protection under environmental laws? So that's the second challenge that we have. So where does it leave us, right? It's been so many puzzles and so many kind of different pieces that are floating around in this presentation. So where it leaves us is with this big question of, what should it mean to have environmental justice? Where do we go from here? Because we do have an increasing amount of inequality, not just wealth inequality. I found an interesting research that during the 18th century, there was a lot more income parity despite slavery, etc., than we have today. Right, we have huge income gaps today than we had in the late 18th century, which is quite startling. At the same time, we also see that our environmental problems are increasing. We do see that climate change particularly is a big challenge. And we do know that we're going to see communities, certain communities, low-income communities, people of color, children, probably older people. There's a Swiss case in which certain older people filed a claim saying that, we are going to be more affected because we as older people are not going to have the same robust resilience to climate change and growing heat. So we see that the communities or the class that is going to suffer a disproportionate impact because of climate change and because of growing environmental problems is actually growing bigger. And still, the law within which you can pursue a remedy is very limited. We don't have a climate change legislation, right? We really do not have concrete laws that talk about how to make sure that there's equal protection. How did we get here? So I'll take a few minutes just to talk about two more things very quickly. The first is, and here's where I think I began to think about how do we look at this problem. And I said, well, let's look at two things. The first thing is, how did we get here? How did we get here where certain communities didn't join the environmental law movement? So if you really go back to our history, what we see is one, that the environmental movement and the civil rights movement were really parallel movements. I always think, and I say this with great pride and with great admiration, right? When I see some of the documentaries involving the Love Canal case, I see Louis, who's the kind of the central figure there, saying that we need homes, that we are relocated from this chemical pollution, that our children are safe, and then locks up EPA officials who come to visit the neighborhood, and then gets a phone call from the White House during the Carter administration saying that we will provide you, temporary residence or temporary relocation until we find a permanent place to relocate you, and no charges for locking in EPA officials. And I think about that moment, right, when you have this, and again, I say this with quite a bit of admiration. I wouldn't find the guts to just, lock somebody up and say, you give us what we want, and if not, we're not letting these officials out. But at the same time, you're talking about a very white suburban neighborhood in which this is happening. And then you think about what's happening at the same time in another America, where people are just fighting for desegregation, a right to schooling, a right to basic housing. So we have actually two parallel stories occurring in the United States during the same period of time. And why am I saying this? I'm saying this only to note that the low income, or even specifically the people of color, Black communities, were not in the same position as others were. So they did not probably even think for a minute that environmental pollution is a problem. They were never exposed probably to the environmental pollution that some of the other communities were exposed to. So it never occurred to them to join or even think of joining the movement any more than the environmental communities thought that might be a problem, right? This was not intentional in any way or conscious in any way. And then I think about this, and this is probably speculation. So what happens? What happens to these, fair housing issues? What happens at the administrative level? Did it happen? I don't know. Could it be that certain communities then who got fair housing ended up in places where, being unaware of environmental pollution, it became quite an administrative convenience. Again, not intentional, but an administrative convenience to be able to locate housing and environmental permits being granted in those communities where there was not a robust awareness about the environmental problems. Did that happen? I don't know. But what I think is very clear is that there are two separate movements, that the civil rights movement was very much divorced from the environmental movement, and that the result is that there's been no cohesion between the two in its inception. But where does that leave us? Where do we go from there, given all the problems that we have from a legal interpretative perspective? And after giving careful thought, I went in from entrenchment, and where I said, okay, should we say that the judiciary has somehow de-entrenched or unentrenched this particular provision? Then I said, well, this is the scope of judicial interpretation. We don't know what that scope is, and it's not up to us to challenge in air. It is not up to me as someone who's not a constitutional expert to get into that, wade into those waters. But what we do need is some kind of perspective here as to how we reconcile these differences. And I thought a fine point to go back to is our Declaration of Independence, because the question has, where is this value? Even if we were to pursue it under the due process clause, for instance, where is the value for equal protection? Where is the value for ensuring that's equal protection or equal burden sharing. And I'd say that we need to think about the Declaration of Independence and think about it carefully. Now, the environment itself has changed, I'm sure, tremendously since the Declaration of Independence, right? So we barely had industrialization in the late 18th century when the Declaration of Independence was adopted. There must have been, a lot of great natural beauty when the Declaration was adopted. There was land everywhere, right? And you see this in the, the founders' vision of the country. They were all agrarians for the most part, who believed in the produce of the land. I think Benjamin Franklin, was particularly, fond of saying that it was the honest way of making wealth was to actually farm and not go to war or even trade, right? So what are can these principles actually endure? And I'd say they should endure. And I say they should endure and they should inform our decision-making in all three branches of government. And that's because it's these principles that eventually led even the founders to think about the question of slavery, that led them to abolish eventually through parallel efforts to get this principle of equality meant to abolish the slavery that we had. So as I said, the Declaration, as someone put it, is the very soul of the American Constitution. It's not the Constitution, but as the Supreme Court recognized in Hicks, the Supreme Court actually recognized that this is the normative foundation of the Constitution, that this is where our norms must flow from. And often there's been much importance given to life and liberty, but I think the pursuit of happiness that is enunciated in the Declaration is of utmost importance because it introduces a moral and philosophical value that is rarely dwelt upon in legal literature, leave alone, or especially in the context of environmental justice. But it is this principle that anchors the other principles, right, which are often viewed as contradictory. So if you talk about life versus liberty in the environmental context, there's always a question, how do you actually reconcile these two? The right to life on the one hand and the liberty to pursue all matters of commerce on the other. But when you talk about happiness, what Jefferson introduced was he defined the affirmative role of the government, not just not just utilitarian maximization of happiness to the greatest number of people, but to secure it to all its citizens. So the pursuit of happiness was not an utilitarian principle. And it also prefaced the consent for government to regulate, creating a duty to secure to all Americans a right to pursue happiness. But what does it mean to pursue happiness if you don't have clean water, if you don't have safe environmental conditions? How can one pursue happiness? And if you look at the environmental movement itself, the environmental movement is located in this consciousness that nature and good environmental conditions are part of who we are. It is integral to our well-being. And so it seems almost like an anticlimax having gone through the various interpretational exercises. But I'll conclude by saying that moving forward, what we have to focus on, or I think what the judiciary should perhaps consider in its interpretation of what it means to have equal protection, is to consider whether the value of pursuing happiness warrants a particular interpretation, not just governmental policies, one way or the other, not just the interest of economic development versus the environmental protection, but that the pursuit of environmental justice is itself a goal that is one with the pursuit of happiness. And I'll stop there because I'm still developing these thoughts and I welcome thoughts. But thank you for giving me this opportunity to talk, and I welcome comments and questions. Thank you very much.
Thank you so much, Professor Badrinarayana. So please feel free to post a question in the chat. And I just have to start off. There's so much there. I think you've really gone through every possible way to try to get environmental justice into our decision making and to impact. I would actually add NEPA as a way that at least some of the courts are looking at. But when you come to the term, how did we get here? I have to say, well, it's the Supreme Court. You know, how, as you pointed out, right, they have changed the level of evidence even necessary to show intent in voting, you know, intentional voting discrimination, in housing, and I mean, and it's not that they would have to do that, right? They don't, that is not, like, I don't think any constitutional law scholar would say that's compelled. They've done that. And so I feel like that's where we've gone wrong. So one of my answers is, well, wow, you know, we need to have different people on the Supreme Court, but that's a little bit different problem. And I think, though, you really identify something very interesting when you talk about the Declaration. I mean, you know, that we've been hearing a lot about the leaked Supreme Court opinion on Roe v. Wade, and one of the things that is somewhat disturbing, considering modern jurisprudence, is the fact that the leaked majority opinion specifies that rights, like substantive due process rights, are to be understood as they existed at the time of the adoption of the Equal Protection Clause and substantive due process. And yet, what you point out, which is a great argument, maybe this is the next Giuliani, is that that did exist. That did exist at the founding. And not only did it exist, it had been explicated, as you point out, by Thomas Jefferson in The Pursuit of Happiness, what that actually meant as an individual right to be clean and free. Now, you know, maybe the Justice Alito would say, well, but he wasn't talking about environmental happiness. I don't know. But again, it gets down to interpretation. So I don't know if you have any comments about that at all. Sorry, that's a lot. It's very provocative.
Thank you very much. No, I agree with you on NEPA completely, right? It's in the, like I said, I'm sorry, my computer just kind of decided to act on me, so I didn't have my PowerPoint slides, so I do apologize. I think it's a great point, and I think, you know, to respond to your question, I agree. I think, you know, the reason I went back to the Declaration is we often stumble, and we seem to think that, I don't know where we start, right? I don't know what the starting point is, whether it's our law school education that we get. And so we look at it in a very doctrinal manner. But I think the starting point is way before. So Jefferson, and then the reason I picked on the Declaration of Independence is that Jefferson could have just taken out from the Lockean theory, right? So his whole philosophy was based on the Lockean theory of life, liberty, and property. And he could have just left it at that, but he made a deliberate choice to not say life, liberty, and property, but said the pursuit of happiness. And so I think I agree with you that when we talk about the pursuit of happiness, we talk about something much more fundamental than you know, life, liberty, or property. And happiness could be different for each other. But when we talk about the individualistic philosophy that we pursue in the United States, we must understand that what it means is that we enable or we ensure that the individual's happiness is not interfered with, because we are a government where the consent to govern has been given on the premise that our pursuit of happiness will be protected. Right. So right, I would say that, you know, if that's the basis, you have to take into account different ways of doing that.
So we have time. I want to give Professor Polsky a chance to ask a question. We have time at least for you to do that, Professor Polsky.
Oh, thank you, Deepa. This was so provocative. And I think you're taking this back to the Declaration of Independence for a solution, a pre-constitutional solution is brilliant and spot on. And I think I lowered my hand because I think you basically just said what I was going to urge you to say in explicating this, which is that the choice of the word happiness over property in that list of three things was so deliberate. I mean, it wasn't just a rhetorical flourish. It was really a Jeffersonian documented decision to elevate this moral consideration and this universality over the sort of crassness of utilitarian focus on property or a focus on material well-being. And so I just think when you introduce this concept it'll be important, as you write about this, to really talk about how, if anything, that word was the most deliberately chosen of the three in that list, even though it's the one that's been effectively written out of constitutional jurisprudence. So thank you so much for this incredible talk.
Thank you so much. I'm so excited to see you finally. We've been communicating.
Thank you. So we are almost out of time. This is so interesting. Thank you so much, Deepa. I really, really appreciate it. I've really enjoyed this. I'm going to pivot over to Aubin for the CLE issues. And thank you all again. And thank you. I know we'll have many more people seeing this recording. It's very, very exciting. I will turn it over to Aubin. Thank you.
Thank you so much. So I've communicated the CLE credit number through the chat box. And in case you have any issue, you can contact directly our colleague, Tanisha Green, with the email conveyed through the chat box. So just one quick thing. Our next speaker will be Professor Katrina Wiman, and she will talk about the crafting of the US energy and climate policy. That will be on June the 2nd. Thank you so much.
Thank you all again so much. Thanks everybody.
Thank you, everyone. Thank you. This was great.
Excellent. Thank you. All right. Goodbye.